Imagine a courtroom in 1386 in Falaise, France. Not an ordinary courtroom, and certainly not an ordinary defendant. The accused stands before a judge, a jury, and a packed gallery. It's charged with a heinous crime, murder. Its name? A pig. Yes, a pig. This isn't some rural myth or a children's fable. It's a matter of documented historical fact. This pig, in a formal legal proceeding, complete with lawyers and witnesses, was found guilty of having by its snout torn and mangled the arm and face of the child, Jean Martin, son of Jean Martin, to such an extent that the said child died. It was sentenced to death by hanging. For centuries, across Europe, from the snow-dusted villages of Switzerland to the sun-drenched vineyards of Italy, animals faced human justice. Pigs, cows, goats, even rats, locusts, and weevils. They were arrested, interrogated, tried, and if found guilty, often executed or excommunicated. It sounds like something from a Monty Python sketch, doesn't it? A ludicrous fantasy born of medieval superstition. But these were deadly serious affairs, meticulously recorded in court documents and city archives that survive to this day. Why on earth would highly sophisticated legal systems responsible for the lives of countless humans dedicate such rigorous attention to prosecuting a common farm animal or even a swarm of insects? What bizarre logic underpinned such an astounding practice? The conventional wisdom says medieval people were simply ignorant, steeped in superstition, and lacking scientific understanding. They must have believed animals were morally responsible in the same way humans were, right? But the truth is far more complex, and frankly, much stranger than simple ignorance. It cuts to the very core of how medieval society understood justice, law, and humanity's place in the natural and divine order. These trials weren't arbitrary acts of madness. They were a direct and chilling extension of their deepest philosophical, religious, and legal principles, and understanding why they happened reveals a profound insight into the medieval mind that still echoes, in subtle and often disturbing ways, in our modern world. So, did medieval courts really put animals on trial? Absolutely. And the reasons behind it will absolutely shatter your preconceptions. The medieval legal system, as strange as it might seem to us today, was anything but primitive. It was a highly structured, often brutal, but undeniably rational framework for its time, built upon Roman law and Christian theology. When an animal committed an offense, it wasn't just a matter of an angry farmer grabbing an axe. It was considered a breach of the divine order, an act that demanded formal legal redress. Think about it. If God had given humanity dominion over animals, and an animal then harmed a human, wasn't that a direct challenge to God's decree? These animal trials typically fell into two broad categories. First, trials of domestic animals, like pigs, cows, and horses. These were usually tried in secular courts, much like human criminals. The most infamous, like our Falaise pig, were often accused of homicide. But there were also cases of animals charged with property damage, assault, or even bestiality. Take the 1474 case. In Basel, Switzerland, where a rooster was accused of the heinous and unnatural crime of laying an egg. Why heinous? Because a rooster laying an egg was seen as an unnatural perversion, a sign of witchcraft or demonic influence. The rooster was found guilty and burned at the stake. The second category involved wild animals, locusts, rats, mice, weevils. These creatures, particularly those that destroyed crops or spread disease, were tried in ecclesiastical courts or church courts. The legal process for them was even more elaborate, almost absurdly so. The animals weren't physically present in court, obviously. Instead, they were represented by lawyers, often some of the most respected legal minds of the era, who would argue their case in absentia. Yes, real lawyers. For vermin. These animal defendants were served summonses, which were read aloud in the areas they were known to inhabit, giving them a specified period to appear in court if they failed to show, which, shocker, they always did. Their appointed lawyer would argue that they were prevented from appearing by reasonable cause, perhaps by impassable, roads, or lack of safe passage. They would even be granted extensions. When the court inevitably found them guilty of whatever plague they had brought, the sentence was often excommunication or banishment, essentially telling them to leave the area, usually with a formal curse from the clergy. This wasn't just symbolic, it was believed to have tangible spiritual power to compel the animals to obey. It was a profound statement of human authority, a cosmic assertion of law and order over the chaotic forces of nature. Now, here's where it gets truly mind-bending. The deepest paradox of these medieval animal trials lies not in the belief that animals were morally culpable, but in the meticulous care and legal rigor applied to their proceedings. These weren't witch hunts born of blind panic. They followed strict legal precedents, often applying Roman law principles, just as if the defendant were a human. Animals were assigned defense attorneys, like the brilliant Barthélemy Chassaneuz, who, in 1533, famously defended a colony of rats in Autun, France. He argued for their rights, citing their difficulty in traveling to court due to the dangers posed by cats, and even demanded they be provided safe passage. He successfully got their trial postponed. This level of detailed legal process wasn't for the animals themselves. It was for the humans. It served several critical, often overlapping functions. Firstly, it reinforced the absolute authority of human law and, by extension, God's law over all creation. By subjecting animals to legal scrutiny, humans were asserting their divinely appointed dominion. If even an animal could be held accountable, how much more so a human? It removed any ambiguity about who was in charge. Secondly, it was a way to restore social and cosmic order in a world where every unusual event, from a bad harvest to a child's sudden death, could be interpreted as a sign of divine displeasure or demonic interference. A formal trial provided a structured, ritualized way to address the perceived transgression and cleanse the community. The execution of a guilty pig wasn't just punishment. It was a purification, a sacrifice to appease God and restore balance. It was a tangible act in a very real spiritual battle. But perhaps the most profound revelation lies in the concept of legal personality. Medieval jurists grappled with complex questions of responsibility. When an animal killed a person, the animal was the instrument of death. But was it the ultimate cause? Some scholars argue these trials were less about the animal's moral guilt and more about making sure justice was seen to be done, satisfying the victims' families, and demonstrating that number matter how seemingly, accidental or perpetrated by a non-human, would go unpunished. It was about defining the boundaries of legal personhood, even if only for the purpose of punishment. The fact that an animal was tried didn't mean it was seen as having the same kind of soul or free will as a human, but rather that it could, in specific circumstances, be formally inked into the human legal system as a perpetrator to satisfy a public need for justice. This is the biggest payoff, the hidden logic. It wasn't for the pig, it was for the people. It was a meticulously crafted psychological and social tool, disguised as a literal application of law. These bizarre legal spectacles, long dismissed as medieval oddities, hold surprising reflections for our own era as we increasingly grapple with questions of animal rights, ecological justice, and even the potential legal personhood of artificial intelligence. The medieval animal trials offer a historical lens. They remind us that our legal systems have always been and continue to be reflections of our deepest societal values, our understanding of responsibility, and our relationship with the non-human world. Today, we no longer put animals on trial, at least not in the formal sense. But our courts are filled with debates about culpability, about who or what is responsible when harm occurs. When a self-driving car causes an accident, who is at fault? The AI? The programmer? The owner? These questions echo the medieval struggle to assign blame and impose order on a complex, often unpredictable world. So, while we might smirk at the image of a pig in the dock, could our own pursuit of assigning responsibility to advanced AI, or even granting legal status to natural entities, like rivers or forests, be a modern, highly sophisticated echo of humanity's age-old attempt to extend the reach of justice beyond our immediate species?